Okay. We're back on the record outside the presence of any jurors. Ms. Manson. While we're in the recess, you asked me to put something on the record, and I told you not at this time. Certainly we can do that now. Tell me what you need me to do.
Your Honor, the state said that the civil attorney for Mr. Rosales was in the courtroom. For record, he has been in the courtroom during the entire trial, and he asked to go speak to Mr. Rosales, who is in the holdover. For record purposes, in the last couple of minutes, we have been talking about whether or not Mr. Rosales would be available to testify or not, whether or not he has immunity, and that what we intend to question him on is perjury. This civil attorney could go and visit him in the jail at any time. The civil attorney would have access to him in the jail at any time. It is right before we are discussing whether or not he will testify that he is asked to go in the holdover and speak to him. I objected. I asked that you not allow him to go at this time, that it was improper, that he was not his criminal attorney, and that he has been present in the trial the entire time. You have, am I correct that you are overruling this objection?
Yeah, I allowed him to visit his client.
And then I asked that since he would be subject to the rule, to pull the attorney out and inform him of the rule and what he can and cannot talk to his client about, and he said that he would not do so. So at this time, he is still in the holdover discussing with his client.
He's behind you.
And that he was in the holdover without being admonished of what he can and can tell him about what's gone on in this trial. That he does have a bias and a vested interest in this. He is not his criminal attorney. And that the defense objects that this is improper and unfair, and it is tampering with this witness before he testifies.
Okay, all those objections are overruled. I know Mr. Washington knows the rules of evidence, and he won't violate them. You ready to do the 702, 703 hearings? For the defense, these are your witnesses. Who's going to do them?
Mr. Prosper is going to do the first one.
You ready?
Yes, Judge.
Who are you going to call?
Tommy Marchetti.
Mr. Marchetti? And for the record, Mr. Mongaris is in a felony trial. Mr. Cairo Johnson is retired, although he owes the court some donuts. So I'm in the process of obtaining an attorney for the witness. Sir, how you doing? Please come on up here. And before you have a seat, if you could raise your right hand. You swear the testimony that you're about to give will be the truth?
Yes, sir.
All right. Go ahead and have a seat. Mr. Prosper, this is your witness regarding the admissibility of his expert opinions and the basis of those opinions. You may proceed whenever you're ready.
You are Tommy Marchetti.
My name is Dudley, D-U-D-L-E-Y, Thomas, T-O-N-H-O-M-A-S, Marchetti, M-A-R-C-H-E-T-T-I, Jr.
People generally refer to you as Tommy Marchetti.
My friends do, yes, sir.
And are you currently retired?
I am.
And where did you retire from?
Dallas Police Department,
How long were you with Dallas Police Department?
32 years, 9 months.
And in what capacity?
I was a detective with the Vehicle Crimes Unit.
And how long were you a detective with the Vehicle Crimes Unit?
14 years.
And did you investigate accidents?
Prior to being a detective, I was an accident investigator.
And how long were you an accident investigator?
12 years.
12 years accident investigator, 14 years.
Detective, and before that I was on the DWI unit for 3 years. And then I spent 40 months in patrol.
And the last portion of your career with Dallas Police Department, were you kind of a liaison between one of the traffic units and the district attorney's office?
I was the liaison, yes, sir.
And can you tell the judge what that consisted of?
My wife worked down here. I came down here 3 times a day.
Sorry.
And did you bring cases down from the Dallas Police Department concerning automobile accidents?
I had over 800 appearances before the grand jury.
That is, the state, the district attorney's office in Dallas County sponsored your testimony some 800 times before the Dallas County grand jury?
That's correct.
And did you present automobile accidents and intox manslaughters, as well as other vehicular crimes?
Murder.
Okay. Can you give the judge some idea of the kind of schools you went to and the kind of background you had to be an accident investigator and perform the duties that you performed the last years of your career at the DPD?
I've been to every accident school there is. I've been to Reconstruction School A&M. I've been to detective development courses. I hold a certificate from, at then TCLIOS, as an instructor, which I earned in 1985. I have over 3,500 hours of teaching at the Dallas Police Academy as a visiting instructor. I've taught accident reconstruction, I've trained detectives, I've trained accident investigators.
And you have dealt with vehicles and the speed with which vehicles travel and injuries that resulted in automobiles and the speeds at which they were traveling for how many years?
I did my first reconstruction in 1988. I did the reconstruction for the first conviction for intoxication manslaughter by the Dallas County in 1995.
And I ask you to look into this case specifically in regards to the speed at which the vehicle that contained Genevive Dawes and Virgilio Rosales, in this particular case, body cams, the speed of the vehicle, circumstances surrounding that vehicle, to determine whether or not that vehicle was capable at the speed it was being driven on the occasion in question on January the 18th, 2017, did I not?
Yes, sir.
And did you do so?
Yes, sir.
And do you have an opinion as to whether or not a vehicle being driven at that speed on the occasion in question, and I think the video is probably slightly over 2 minutes long, involving the vehicle moving? There's several maybe minutes before with the police officers trying to get them out of the vehicle. Do you have an opinion as to whether or not a vehicle driven at that speed is capable of causing death or serious bodily injury?
I do.
And what is that opinion?
It is.
Judge, I would first of all stipulate and ask the district attorney's office to stipulate that he is qualified as an expert to testify about this subject matter.
Mr. Mitchell?
I'd like to ask him a few questions regarding that, Your Honor.
Okay. All right. Do you have any other questions that you want to?
No, I do not, no.
Okay, very good. Mr. Mitchell?
Yes, sir. Mr. Marchetti, my name is Brian Mitchell. I'm a prosecutor here. I'm going to ask you a few questions, okay?
Fine.
How fast were the cars going? Was the car going?
Which one? The one we're talking about today?
The one you're talking that you say
2.9 feet, 2.9 miles an hour walking speed is what the expert refers to it as.
I'm asking you, how fast was it going?
I have no idea.
You've not done a calculation as to how fast and what I'm talking about is the Dodge Journey.
I know.
Okay.
No, I have not.
You have no idea how fast it was going?
No.
Okay. But you're here today to tell this jury, presumably, that the car going at the speed that we see on the video would cause serious bodily injury or death to someone that is drunk.
Yes.
Okay. But you have no idea how fast that is.
Walking speed is what your expert said.
Sir, my expert hasn't testified in front of this jury. You understand that?
Yes, sir.
Okay. So the jury has no benefit of what they're going to say.
Okay.
At this point. Okay. So I guess my concern is why would you opine that that car could cause serious bodily injury or death if you have no idea how fast it was going?
Well, cars only go so fast backwards.
How fast can a Dodge Journey go backwards?
And that parking lot, 10, 15 miles an hour.
Okay, how fast was it going?
I don't know.
All right. How fast does it take to go up to 10 or 15 miles an hour?
You know how quick?
How quick?
5 seconds.
All right. How many feet would it cover?
In 5 seconds to go 15 miles an hour?
Sure.
7.5 times 1.5 times 5.
Okay. What is that?
7.5 times 1.5 times 5 is 12 times 5, 60. 60 feet.
Was it going that fast in this case?
I don't know. It could have.
But I thought you just said that it was limited by the distance and it couldn't reach 15 miles an hour.
It can back up as fast as 15 miles an hour.
But you don't know how fast it was going.
No, but I know what the potential is.
Let me ask you this. Are you going to offer an opinion about how, let me ask you this, is any speed, any velocity from a motor vehicle enough for you to opine that it would cause serious bodily injury or death?
I have 10 examples in my briefcase of cars going walking speed that have caused death,
Okay.
both forward and backwards.
So you're going to testify to those things,
Yes.
those cases?
Such an ironic statement. Go ahead. Sorry.
So the 10 that you have in your briefcase, did you calculate speed on those?
They're going backwards according to the reports, just backing up walking speed.
So the answer is no.
No.
Okay, let me re-ask it because it could have been a double negative. Of the 10 cases in your briefcase that you're speaking about, okay, did you do speed calculations on those?
No.
And of those 10 cases in your briefcase, you believe that speed was the cause of serious bodily injury or death?
No, the vehicle was.
Okay. Did the person walk into the vehicle?
Nobody walked into a vehicle. Some people got run over by their own vehicles.
Okay. How fast was it going?
Well, some of them, they didn't see it happen. It just idled over them.
That's perfect. That's a perfect example. If someone's back is to a car that's coming up on them, would you agree that that could be an issue?
Yes.
That could cause serious bodily injury?
Yes.
Even a slow-moving vehicle.
Yes.
Somebody sleeping on the ground, a slow-moving vehicle could cause
Yes.
injuries, right? Okay. What about someone who's able-bodied and sees it coming?
I don't know. It depends on how able-bodied they are, how much extra weight they're carrying, what the surface is, whether it's dry, wet, leafy.
Do you know any information about the officers in this case?
I know one of the officers.
Okay, there were 6, as I understand it, at the scene. Do you know anything about any of them?
No, just Officer Wilcox. I knew him when he was in traffic.
Okay, so you don't know about any of the officers that were even involved in this issue?
Mr. Hess.
Okay, so you know 2.
Yes.
Okay. Do you know Hopkins?
No.
Officer Hopkins, do you know Officer Kemble?
No.
Okay. You don't know what their physical limitations are, if any?
I do not.
You know what their hearing's like?
I have no idea.
Like vision?
Again, I don't know.
All right. And just so I'm clear, you want to offer an opinion to this jury that based on, well, let me ask you this, what are you basing this on? Your opinion that that vehicle that night could cause serious bodily injury or death?
Well, of my experience.
What have you reviewed in this case that gives you that opinion?
I've got 10 crashes in my briefcase that show that it didn't cause death.
Have you reviewed anything in this case?
Yes.
What have you
I've read
reviewed?
their statements, the officers' IAD statements.
Okay, so you haven't reviewed any body worn cameras?
No.
Do you think would be important to determine whether or not the vehicle in this case would cause serious bodily injury or death? To have actually watched video of it?
A vehicle in that size of area could cause serious bodily injury, anything within 20 feet.
Okay, so you're saying you don't need to see the video?
No, I haven't seen the video.
And I'm saying you don't even need to see the video to issue your opinion?
Oh, I'll watch it if you want me to.
I bet you will. I'll pass the witness, Judge.
Officer Marchetti, your testimony here today, that a vehicle moving at a speed of up to 5 miles an hour, 2.5, 3 miles an hour, is capable of causing death or serious bodily injury.
Yes.
You don't need to see this vehicle run into a fence at 4 or 5 miles an hour to determine that if a person is hit instead of the fence, that vehicle is going to cause death or serious bodily injury.
That's correct.
And if the vehicle is backing up and even going 2.5 miles an hour, if that vehicle hits somebody, it's going to cause death or serious bodily injury.
It will.
So the extent that they've tried to insinuate or imply that the slower the vehicle, the impossibility of causing death or serious bodily injury, that's just not accurate, is it?
No.
I'll pass the witness, Your Honor, and submit that he's eminently qualified based on the number of times he's previously testified, based on his experience, and based on the facts of this case, he ought to be allowed to testify that a vehicle going 2.5, 3 miles an hour is capable of causing death or serious bodily injury.
Your Honor, obviously, the state's going to object to him testifying to that. We have no issue with his qualifications. We thank him for his service of all these years. The problem is, he's being asked to opine about a specific issue in this case, and he hasn't even reviewed anything. He doesn't even know how fast the cars are going. And we've had multiple officers get up here and testify that they all thought the car was a deadly weapon. So this serves to confuse. He's being propped up as an expert on this, but he hasn't looked at anything. He hasn't done a report that I've seen that's been turned over to me. He hasn't even looked at the body-worn cameras. So it sounded to me like he was trying to rely on the state's expert who hasn't testified yet. So for those reasons, Your Honor, we would object to this expert testifying to that statement that he wants to testify to.
Okay. I'm going to overrule the state's objection for that proffer, which is that a car at 5 miles an hour or less can be a deadly weapon. So for that purpose, the officer can testify. I'll give you a running objection. If you wish for one, do you want one, Mr. Mitchell?
Yes, Your Honor.
Okay, it's granted. Is there anything else for this witness this afternoon?
Not this afternoon, Judge.
All right, sir, you may stand down. Thank you
Thank
very
you, Your Honor.
much. And who will be handling the next expert for the state? For the defense, sorry. Okay? Come on up here, please.
Defense calls Jerry Staton.
And before you have a seat, could you raise your right hand? You swear the testimony you're about to give will be the truth.
I do.
Please have a seat. You're responding to questions from Ms. Madsen first, perhaps also
Ms. Nicholson.
Ms. Nicholson. Very good. Welcome back. Ms. Madsen?
Mr. Staton, will you introduce yourself to the court?
My name is Jerry Ray Staton, S-T-A-T-O-N.
May I approach the witness?
Yes, ma'am.
What number am I on?
I said 41.
Is Defense Exhibit 41 a copy of your current CV?
It is.
And would this aid the court in understanding your qualifications in this case?
I do believe yes.
Defense would offer Defense Exhibit 41 into evidence for record purposes and for the purposes of this hearing.
No objection for record purposes, for the purposes of this hearing.
It's admitted for record purposes only.
Mr. Staton, will you go ahead and start going through your training and experience?
I was a little over 25-year police officer with the city of Austin. Started in 1975, and as with all police officers, went through about a 6-month, for Austin, went through, about a 6-month academy before being released to the street to work in patrol. I worked as a patrol officer responding to calls, as so many other officers up here have testified, for approximately 5 years, just a little over. Took the test and promoted to detective. It's a little confusing. If you look at the record, it says sergeant investigator, but it's the same thing with a different name. I was a detective the rest of my career. As a detective, my first assignment was to remain with the shift on the street, but I went into plainclothes. It was an experimental program where they wanted to have someone on the street that had a little more experience and could I guess, assist some of the supervisors with some of the more complicated crime scenes. So I had run of the city, if you will. Whenever something occurred, I could go anywhere in the city. I wasn't restricted to one small area. I did that for approximately 6.5 years. When I left there, I went into my first assignment with the SWAT team. My position was about 1.5 years or 2 years later was transferred, so I had to leave, and I went to CID as a regular investigator, as we called it, driving a desk. Spent about 3 years there, came back to the SWAT team, ended up with a total of 8 years on the teams. I spent the last 3 years of my service as a full-time instructor in the academy, teaching both use of force skills and use of force concepts. After retiring, I started my own training business, teaching the same things, skill sets involved in using force, along with the concept of when force was justifiable and how much force was appropriate in certain situations. I became involved with what was then a brand new company called Taser International, became an instructor for them, stayed with them as a contract instructor all the way up through and became a senior master Taser instructor, certifying other instructors and senior and master instructors. And I bring that out because as part of that, I was a training advisory board member with the company when Axon cameras, body-worn cameras, were first released. So I'm very familiar with the whole camera issue. But my entire career has really been centered around use of force, both as the skills and the concepts involved. And then I guess I sort of fell into the expert witness end of it because of all the teaching and instruction that I was doing. I have been providing that expert witness for probably 15 years.
Have you been certified as an expert in Texas
Yes.
and any other states?
I have testified in, I'd have to go back and look to be exact, 5 or 6 other states in both federal courts and district courts, in both civil and criminal, in both defense and prosecution, and in both plaintiff and defense. So I've pretty much covered the board.
In what areas do you have that expertise?
Well, I have a number of areas that would qualify for a jury as being an expert, all police related, of course, but I limit my expert witness work to use of force issues, and sometimes that involves some tactics because of my SWAT training, but it's all pretty much related back to that. But under that umbrella, and I spent a lot of my own time and money becoming expert and teaching in what I like to refer to as human limitations. It's been referred to in this courtroom a couple of times as the force science issues. It's a sort of a misnomer, although force science is the institute that has brought a lot of this to light by putting research behind what we as experienced police officers know, that it's not really the exact correct term, but it's really referring to what human beings are able to do and what some of the limitations and restrictions they have, particularly in situations involving use of force when they're under stress.
And you formed opinions regarding those topics in this case, correct?
That is correct.
And what are those opinions based upon?
Based upon all of that experience, knowledge, and extra training, and reviewing, if we'd like to do that here, reviewing all the material that I had requested from you that you had provided to me, being all of the video, all of the body-worn cameras, all of the officers' statements. I have also already seen the exhibits that have yet to be presented to this jury that were computer generated from the experts that have yet to testify. So pretty good amount of material that I have gone through before I made my ultimate decision.
And you have requested specific material from me, correct?
That is correct. I should include also, I've read the grand jury testimony, grand jury transcripts that I had asked, which you provided.
Briefly, Your Honor.
Yes, ma'am.
Good afternoon, Mr. Staton. My name is Mashika Nicholson, and I'll be asking some questions.
Good afternoon, ma'am.
What exactly has the defense retained and asked you to do in this case?
I'm sorry, I believe that's two questions.
So the first question, what did the defense ask you to do in this case?
They wanted me to analyze the information that they made available to me to make a determination about the force used by Officer Hess on the morning in question where he encountered the stolen vehicle with the two occupants.
And do you have any opinions that you intend to offer before the jury?
Yes. If asked, I would certainly say that I believe that based on all of the information that I think was available to Officer Hess at the time that he made the decision to use deadly force, that it is reasonable and understandable that he would take the action that he took.
So you said reasonable and understandable, and what exactly helped you form that basis?
Every bit of the information. The videos were very helpful, but videos are limited. You can never form a good objective opinion based strictly on videos because videos do not see what the officer perceives. If you want a little narrative, I can continue, or I can ask specific answers to questions.
Well, I've got some questions specifically for you, but
Yes,
I guess
ma'am.
I just want to go back into, so you said it was reasonable and understandable. Please help me understand what specifically, like what are you going to explain to this jury as to why your opinion is that the defendant's use of force was reasonable, based on what specifically?
Well, based on looking at the material that was provided, but based on my knowledge that I suspect the jury doesn't have when we get into that field that has been referred to as the force science issues. It is unrealistic to expect a police officer under stress to do some of the things that the prosecution seems to believe that he should have been able to do. You've heard multiple officers up here say that their focus was on the threat, their focus was on the car. There is ample research to support that that would be the normal course for a human being under a certain amount of stress. It gets a little difficult here because I can't say specifically how much stress Mr. Hess was experiencing. But I can say that the information I've received is consistent with the research to suggest that what he was experiencing was normal, which means that it would be highly unlikely that he would be able to keep up with all of the people who were moving about during that scene, which was tense, uncertain, and rapidly evolving, that he was under a certain level of stress and that he was focused on the threat and not on exactly where everybody was at exactly every moment.
And that brings me to my next question, which I think you just stated, is that do you know exactly what the defendant was thinking at the time that he decided to use deadly force?
I would suggest to you that not even the defendant knows exactly what he was thinking. He was falling back on his training and his experience, and he made it, and I assume that he made a decision based on all of that, but there's no way that anyone can know what's in someone else's mind.
And that's my next point. So there's no way that you could testify before this jury that you know what exactly was going through the defendant's mind.
I would not even attempt to do so. That is outside the realm of any human being's capability.
And are you going to offer any opinions as to exactly what the defendant felt stress-wise level?
No, ma'am, that's also impossible.
Because those facts and information could only come from the defendant himself, is that correct?
I would agree with you, yes, ma'am.
He would be the best person to say what level of stress he was feeling, what his heart rate may have been experiencing, where his actual vision was focused on. That would come directly from the defendant.
Well, the way you stated it, I would have to say that even he would not be capable of delivering all of that accurately, but I do agree that the best information available as to what he was thinking would come from him.
And I believe you also stated that there were some studies. Do you plan to offer any testimony regarding studies before this jury?
No, ma'am. If I brought in all the studies that I have reviewed and looked at, there are literally hundreds of them. I don't think we would get through this trial for the next 2 weeks.
And Mr. Staton, what standard are you using when you judge the defendant's reasonableness of his actions?
I am doing the best job I can to use the objectively reasonable standard, which, if I may go on, I believe this case is pretty simple. It's really based on would another person, another police officer in this case, under similar or the exact set of circumstances as Mr. Hess, because we had other officers there who were under the almost exact same circumstances, would they likely have used the same level of force? And we've got one other officer who did, and two other officers who said they would have, except they didn't have a clear shot. To me, my job was simple. Using the objectively reasonable standard, would another officer have done it? They already did.
And so you're saying you're using the objectively reasonable standard, but what are you familiar with the standard of reasonableness here under Texas penal law?
I've read it. I couldn't recite it to you. I could certainly read it again if you chose to ask me to.
And so your opinions regarding the reasonableness of the defendant's use of force is based on the objectively reasonable standard. Is that correct? What another officer would have done in a similar situation?
What another person acting in the role of a police officer with the training and experience of that police officer in a similar or this situation, that's the standard that I'm using. And again, that's not 100% accurate because the other officers on scene didn't have the same experience as Officer Hess. And yet they came to the same conclusion, or some of them did.
Excuse me, I didn't mean to interrupt you.
Nor did I mean to interrupt you.
The objective reasonable standard, where does that standard come from?
Graham versus Connor, the Fourth Amendment,
So Graham v. Connor, that is a Fourth Amendment United States Supreme Court case, is that correct?
1989, yes ma'am.
And is that dealing with a civil matter, civil rights issue?
It was, and it is, and that standard has been accepted across the board, to my knowledge, in thousands of both civil and criminal cases.
But you understand that here in the state of Texas, that the law that's applicable in this state action, the criminal action for an aggravated assault by a public servant, that we are bound by the confines of Texas law, and that the standard that we have to operate under is the ordinary and prudent reasonable person standard based on Texas law. It's not the objectively reasonable standard.
I do understand that, but you're talking about the same animal in a different suit.
How so?
Splitting hairs when you look at the difference. So we're looking at the Texas law, which refers to a reasonable person. The Supreme Court decision in the Fourth Amendment issue is talking about an objectively reasonable standard for another officer. But when you go back to the Texas law, it's another person in the role of a police officer. I realize it's not the same thing, but the difference is subtle. So what was I said objectively reasonable because I'm so used to testifying to that, but I obviously went back and looked at and reviewed the Texas version and came to the same conclusion.
Mr. Staton, what is the definition of a reasonable belief?
Again, I can't give you the exact verbiage out of the penal code or the criminal code of criminal procedure, but a reasonable belief is, and it's hard to define without using the word reasonable or a derivative of it, is what a normal person under similar circumstances would likely have done. It goes back to, is it likely that another person would have done something similar? I realize that's not exact verbiage.
And what other opinions do you have or intend to offer before the jury?
That I wouldn't know until I was specifically asked. It depends on, I guess, what questions are asked and what road we go down. It's all going to come in under the issue of use of force by a police officer and or a reasonable person, and the human factors that we have touched on very, very briefly. I haven't gotten into detail on those.
And Mr. Staton, are you a paid expert?
Yes, ma'am, I am.
What is your hourly rate?
My hourly rate for doing research is $100. My hourly rate for depositions is $200 an hour. My rate for this trial will be $1,000 a day.
And so at the conclusion of this trial, and I'm not aware, were you in the courtroom throughout the entire trial this week since Tuesday?
Unfortunately, the answer is yes.
So leads me to my next question. What do you estimate that your final bill will be for this trial?
You want bill including expenses or just
Total bill?
somewhere under $5,000?
I'll pass the witness.
And I would submit to the court at this time that the expert has proven that he is an expert in the use of force and tactics and all of the things that he offered. We ask that he be allowed to testify in front of the jury.
Ms. Nicholson.
Yes, Your Honor. I don't find any issues with this expert's extensive background and qualifications. However, I do have a problem with the fact that he's rendering or is wanting to render an opinion before this jury based on a standard that is not Texas Penal Code, Texas law. He's citing from Graham v. Connor, which is a civil standard, and I believe that more particularly that was only going to confuse the jurors in this case because they are not deciding whether or not that this defendant's actions has violated Ms. Dawes' Fourth Amendment rights. We are here for an ag assault by a public servant case based on Texas law under Chapter 9, and I believe that he's applying the wrong standard. Even in the proffer today, he stated that it's so common in his mind to confuse what a reasonable officer would do objectively, reasonableness, versus the Texas standard of the ordinary, reasonable, and prudent person.
How are you going to address that?
Your Honor,
Through questioning, sorry.
we took this up in a motion in limine before the court, and the court's ruling was that people were not to cite the case in order to have authority, but they could use wording from that case and phrases and common phrases. He was using that wording. Then they asked him about the law. Those are two separate issues, and they're going to use similar phrasing, and they're going to use similar wording. I did not have him cite that case. I did not have him cite the authority, as the court told us we should not. However, the reasonableness, the reasonably prudent person, a reasonable person in the defendant's shoes with his training and background, all is relevant and are things that are appropriate for him to testify as an expert. I intend to honor the court's ruling. I intend to not cite the case or give it any authority or tell this jury that it's the ruling. The court will give them the charge, the court will give them the law.
Okay.
And Judge, if I may respond to that.
Yes, ma'am.
Yes, the ruling was to not state the actual case names. However, this witness has stated that his opinion regarding the defendant's reasonableness of his action is based on an improper standard, is based on the wrong law, and that when a witness testifies as to a mixed question of law and fact, the witness's opinion will not be helpful unless the witness understands the underlying legal standard. And in this case, that is the Texas Penal Code, Texas law. Additionally, I would also like to state that the witness stated during the proffer that he can't render any opinions as to what was going through the defendant's mind regarding the defendant's level of stress or any other physiological things that the defendant may have been thinking or going through at that point in time, as the best person who could provide that information would be the defendant himself. And furthermore, this witness has stated he doesn't even think the defendant could render such testimony himself.
All right. I'm going to overrule the state's objection and allow the witness to testify congruent with the proffer that was made by Ms. Madsen. Is there anything else that we need to put on the record before we recess for the day?
Nothing further for the state.
And I would like to answer in regarding Mr. Rosales and what he intends to do. Obviously, there are multiple steps. I understand if he can't get it done today, but I have things I have to do in order to figure out what we're going to do. If he is going to invoke his Fifth Amendment rights, if he is not going to invoke his Fifth Amendment rights, what character evidence will be admissible, what will not be admissible, what will be used to impeach him, what will not, whether or not we'll get into grand jury testimony, whether or not he is immune from perjury charges. So I understand that you were trying to get him an attorney. I would ask that we know our status on that and when I will have those answers.
As soon as I can possibly make that happen. Is there anything else that we need to put on the record this afternoon?
If I may, just briefly.
How you doing, Mr. Lewis? Go ahead.
With regard, I just want to clear for the record, with regard to the Brady violation accusations with respect to Officer Hopkins, who was represented to the court. Officer Hopkins told me some information, specifically that he believed that the defendant's actions in this case were reasonable, and I believe I thought I made it clear in that hearing at that time that he never told me that. Let me just say further, in these kind of cases, especially after the case is indicted, I don't ask any witnesses that I think the defendant acted reasonably. I ask what they did, and get clarification on what they did, why they shot, why they didn't shoot, but I don't ask any questions as to whether or not I believe the defendant acted reasonably, because at that point, the grand jury has found that he did not. As it pertains to Detective Richardson, there was also an accusation made that he told me that he felt as though the defendant's actions were reasonable. I represent to the court that in my interview with Detective Richardson, again, he didn't tell me that. I didn't ask him that question. However, and I believe I've stated this on the record before too, in the grand jury transcript, he does testify to that, and that was information that was provided to the defense back in April 2019. So I just want to make it clear for the record that I'm denying those accusations. And with regard to Detective Richardson, that was information that the defense had in their possession.
Thank you. Is there anything else?
With respect to the videos, the body worn camera videos that were missing, Investigator Lenore is working on that, and he should get that over here as soon as he can. It's my understanding that they're being copied right now and being brought back for the defense.
Could I just have clarification, because he's saying videos. My understanding was that it was one video, Officer Wilcox. Are there additional videos as well?
There's more. To my understanding specifically, Officer Wilcox's video was 2 minutes, and there is no contact with the defendant on that particular video. These other videos that are outstanding are officers that responded well after the incident and were there just to kind of put up crime scene tape and protect the crime scene. So there's no information pertaining to the defendant on those as well.
Let's not speculate if we don't know what these videos are going to be like, what's going to be on them, or who they belong to, or where they were created. As soon as you have that information, share it with Mr. Harris, and we'll go from there.
Yes, sir.
All right. Is there anything else we need to put on the record today? That's it. Court's in recess. Thank you very much.
Y'all retreat on the exhibits over there.
I think you're there.
Thank you.